You also can just raise your hand. We can see that. So.
Right. Well, I don't know.
Okay.
Let's see if we'll be able to see it now.
Oh.
So here we go. Can y'all see our screen?
Yes.
Okay, great. So what does a durable power of attorney do, and why do you need one? Well, so about half of us are going to be incapacitated at some point in our life, and as a result, we'll be unable to make certain kinds of decisions for ourselves. The durable power of attorney focuses on financial decisions and decisions, sort of general decisions other than medical, decisions about medical procedures and therapies. And so we're going to talk about that one because that's the one that generates the most trouble.
And you need one so that someone can make that in the event you become incapacitated, that there's someone who's legally empowered to make decisions for you and to interact with your IRA custodian and your banks on your behalf.
So what happens if you don't have durable power of attorney and you need one because you're ill or in a coma or begin to suffer from dementia or some other debilitating condition?
So what happens then is that someone has to go to court to ask the court to appoint them as your conservator to have the authority to make decisions for you. And if it's an uncontested proceeding, it still can take about a month or so to get that to get the court order, and there are some expenses involved in that. So it's usually a few $1,000s to get that done, even if it's uncontested, between the attorney fees and the fees for the guardian ad litem, who is the court-appointed attorney that's sort of the eyes and ears of the court. So it's not inexpensive. It's certainly much more expensive than getting a power of attorney in place in advance. The other issue is that when you're going to court and asking the court to appoint someone for you, or when someone's going to court asking the court to appoint them as conservator, you have to give notice to the next of kin. So to the extent there are other people in the family, close relatives, who might disagree that you're the best person to be making financial decisions for your loved one, that can result in a contested guardianship conservatorship, which is basically like, it's almost like a child custody battle where you have family members fighting each other about who should be responsible for this loved one who's incapacitated. So as you can imagine, it's not only an expensive proposition, it's very, very emotional and very stressful for the people involved. So it's really important to get these documents in place right away for everyone. Anyone 18 and older, we strongly suggest should have these documents in place, because any one of us could be in a car accident or have a fall or anything, any number of accidents that could happen that could result in us being incapacitated.
So just to go back to the basics for a moment about the reason why you have to have a guardianship if you don't have the power of attorney, is that in Virginia, individuals are allowed to own property and conduct their own business, even if they're married. Imagine that. The result is that the law doesn't automatically allow your spouse, for example, to take care of your personal business if you're not able to do it. So unlike some states where husbands and wives are considered basically interchangeable in terms of their dealing with their personal property or their own property, Virginia requires there to either be an attorney, a power of attorney in place, or for there to be a guardianship, even if you're just taking care of your spouse or your child.
And it's often the case, and it's a heartbreaking situation where we have a spouse that needs to seek guardianship, conservatorship for their husband or wife, just because the husband or wife has a separate bank account or an IRA. IRAs are owned by the individual, and so if they need to perhaps withdraw some money from the IRA in order to be able to get care, additional care, if they don't have a power of attorney, then they need to seek the court, ask the court to give them the authority and appoint them as conservator.
So the basic requirements of a valid durable power of attorney are really only two. You have to have the legal capacity to create a power of attorney, which basically just means that you have to understand the essential ramifications of creating a power of attorney, and you have to have your signature notarized by a notary public. The notarization requirement is one that's relatively new in Virginia, but was put into place in the hopes that it would have a sort of a deterrent effect on some of the foolishness that's gone on historically around people executing fake powers of attorney and so on. As far as the capacity question is concerned, I should say that in order to have the capacity to enter into a power of attorney, you basically just have to understand what the point of the power of attorney is. In other words, that you're appointing a person to conduct business on your behalf, and you need to be able to understand the potential effect that might have. So you need to understand that that person could do things in connection with your estate that you might not do yourself, and you might not be able to undo them.
I would suggest that, and we deal with this a lot, we deal with clients who have diminished capacities, I'm sure all of you do as well. And I would say that the capacity that's required in order to execute a power of attorney, there's a higher level of capacity required than to execute a will. The standard for capacity for executing a will is quite low. You just need to know who you are, who are the people that are closest to you, and what do you have. For a power of attorney, it's a little bit more. It's almost like the capacity to be able to enter into a contract.
It's more conceptual.
Yes. And so we have had situations in which we felt like someone might have testamentary capacity to sign a will, but not the capacity to sign a power of attorney.
Actually, it happens all the time.
And then I also would say that something that's confusing, and I almost have to think that lawyers who are in charge of at least lobbying for the changes in the rules have something to do with this. But each of the different documents that you would have in a estate plan has a different requirement for signing. And so a will, you need 2 witnesses. And if you can have a notary and also have a self-proving affidavit, then that is ideal. So really with a will, you really ideally want 2 witnesses and a notarized signatures. For a healthcare power of attorney, you just need 2 witnesses. You don't need a notary. And for a power of attorney, a durable power of attorney, you need a notary but no witnesses. So you know.
Who's keeping time? Because we're not paying attention to the time. Could somebody tell us who's got the time and how much we've got left?
Are you going to buzz us, Angie?
You've got the time, Raquel?
It's 9:24.
Okay.
When are we done?
We have until 10.
Yes.
Oh,
we have plenty of time.
Okay, well, here we go. So here's one of the thorny issues, probably the most difficult issue in connection with the actual substance of the power of attorney, and that is, who do you name as the agent under the durable power of attorney? And I guess really a couple of attributes come quickly to mind. One, and probably the most important one, is trustworthiness. Mm-hmm. Who do you trust? And who do you think is a person who would be willing to exercise their decision-making authority and power in a way that's in your best interest and perhaps not necessarily in their interest? Those people are not easy to find.
Well, maybe they're not easy to find. Sometimes people they feel like they need to name the person, like I have to name my oldest son because he's my oldest son. I would say that you want someone who's trustworthy. You also want someone who's good at record keeping, who's going to be fairly organized. And if you don't have someone like that, then someone who will seek help if they need it. So someone that you trust, who if they know they aren't that great at record keeping, will find someone who can help them with that or will ask for the help of an attorney.
I want to talk about the oldest son decision. I think to make the decision about who is going to be your agent under power of attorney just based upon the order of their birth, is probably not a good basis in many cases. And this is the tension, you know, that we see in practice. Parents want to name their oldest child, or they want to name their daughter, for example, just because they think it's the role of the daughter to take care of them. And that person may not be confident to do it. And more importantly, they may not be able to see the difference between their interests and their parents' interests. That is most often the case. So,
I also
you know, naming somebody because they're your child or because they're your oldest child or something like that only makes sense if they actually do qualify in terms of their trustworthiness and their competence.
I also want to say that a lot of times parents resolve this issue of who to name by trying to name two people jointly, or even two people who can act separately. And it's always our preference to try to help our clients try to prioritize those people. So we don't advise naming jointly at all, because just purely jointly, because, you know, it makes it very difficult to use the power of attorney. If someone is sick or traveling and the other one needs to make a decision and they can't get in contact with the other person, it ties their hands. There are some banks that don't like to take powers of attorney that required people to act jointly, but there's also some financial institutions, and I'm looking at Don here, I think I'm right about this, that even if you name them jointly, but they can act individually, they will still require both signatures. Am I right about that, Don? At least for Edward Jones?
You're absolutely right. There are certain things like creating accounts or transferring money to an unrelated party that have to have both signatures, because it's critical we document, even if one agent can authorize, that they're not hiding things or being squirrely and trying to deceive the other agent. So a single agent is always ideal.
It's a great policy.
So as attorneys, when we're advising our clients, we're always, of course, we want them to accomplish their goals. We want them to be able to name the people that they want to name. We want their documents to have all the right language in it. But we also, one of our primary goals in helping advise our clients is to make their plan practically work the way they need it to work. So if they are incapacitated and loved ones are stepping up and trying to help them, that means there's a crisis going on. Everybody's under additional stress, and we want to try to make things as easy as possible on the people that are trying to help our clients. And so that's why we try to encourage them to prioritize who they want to name, one and then the other, rather than both.
I've got one more thing I want to say about this slide before we go to the next one, and that is that sometimes, and maybe often, people don't have anybody that's really qualified to name as an agent. That shouldn't keep you from creating a durable power of attorney, because there are people who are trustworthy and whose job it is to do this work. We are among those people, for example.
But so is Katie Caverly.
But Katie Caverly is a good example of somebody who would be a good professional third party to act as an agent under a power of attorney. And of course, you know, there are professional fiduciaries that are available that, you know, can be found, and really it's just a question of, you know, consult with your lawyer about who to name if you can't think of anyone, and we'll go through a process with you that's designed to help you pick the right person or right entity to serve.
Some people have a concern about the cost of a professional fiduciary. And I would just say, if you're considering a professional fiduciary because you don't have someone that you would, either you just don't have someone that is obvious that you could name, or the people that you could name, you have a concern about them fighting with each other or trust issues, having a professional fiduciary in place is certainly much less expensive than your loved ones litigating against each other and fighting each other rather than joining together to help care for you.
Which makes a really good segue into the next section here, because we are going to talk about where the...
You've got a question.
Oh, great.
Robin's asking, what is your opinion about spouses or siblings as power of attorney?
I think it's great, and it's a very common choice. The spouse is almost always the first choice, and siblings are a great choice as well. You know, it's a big responsibility. So sometimes when you have young adult children, eventually they'll be ready to step into that role, but it might take a while. And Robin, I think you have some, and I have some myself that are young adult children. So the siblings are excellent choices. You know, if they're responsible and trustworthy, then they are great choices.
Right. If you can stay married to somebody, if you trust them enough to stay married
through COVID-19,
and then probably they'll be all right. So here's where it gets interesting. Let's talk about some.
There's another
some
question.
Mm-hmm.
Okay.
Tulia is asking, how much does a professional typically cost?
It's a good question. It varies really. Some will work by the hour. Others will want to actually be compensated based upon the magnitude of the estate that they're managing for the person.
I think a typical like hourly rate is anywhere between like $150 and up.
Yeah.
So I know there's the Fairfax Commissioner of Accounts is a very he has lots of great information on his website, and he has a guideline for the fees that should be paid to conservators that are appointed by the court. So someone who's appointed by the court in the same role as an agent under a power of attorney. And I usually use that as a guideline even for my private agents who, so if you appoint someone privately, we think you should include in your power of attorney a provision saying that they should be reasonably compensated, because it is a job. It takes a lot of work. And when our private agents ask us, how much can I pay myself or how much can I be paid, we use that court guideline as a guideline for a fee. Now, obviously, if it's a bank or something like that, it is going to be more expensive than someone like Katie is an excellent choice and also very affordable. Michael and I have not served in that role as agent, but we do advise agents on how to carry out their duties and assist them, and we do that on an hourly basis.
We still have more questions.
Oh, good. That's good.
So Fred is asking, is a power of attorney and durable power of attorney the same? And Tulia is asking, who is Katie?
So let's take the first one. Let's take the second one first. Talk about Katie, honey.
So I should let someone from the Aging in Place talk about Katie, really, because she's on the board. She owns iCor Charlottesville, and they provide a number of different services similar to some of the things I think some of you all do. But I don't know, Angie, do you want to give a quick, or maybe from the chamber, I don't know, someone give a quick Katie Caverly.
Angie, can you go ahead?
Sure. Katie, like Lelia said, owns iCor of Charlottesville, and they do a million different things. They advocate for their clients if they're in the hospital or in some other type of emergency situation. They provide care in the home. They will go in and assess facilities, and they vet all the facilities in town. They can sort of go in and observe certain situations. If you've got families in conflict, I know that Katie has gone in and observed for a couple of hours and then given a very detailed report. I just saw a commercial the other day for transportation. They've got a transportation vehicle now. And so it's a really all-encompassing care management, advocacy, and care type business.
Angie, if I could pipe in,
Sure.
I think the easiest way to explain iCor is complete elder care management. They will step in a fiduciary capacity. They will happily serve as durable power of attorney to run an older person's life if that person doesn't have a nearby family member or anybody else they can rely on. And so they may not directly provide in-home nursing care, but they'll be the ones that would hire Regina's company because they've decided that they're the best for this particular senior, and make sure that everything happens well. So
I think Katie, she sort of thumbnails what she does as basically a paid eldest daughter. So that's kind of I think that epithet is really fitting. Moving to the first question about what makes a power of attorney durable as opposed to a traditional power of attorney. Well, I have to define both of those things. A power of attorney traditionally is just a notice that a person signs that puts third parties on notice that there's going to be somebody who is acting on their behalf with respect to them. And so to put that in sort of more layman's terms, it's like a note that you write to a bank, let's say, telling the bank that Fred is going to be signing for you for some period of time. Now, traditionally, a power of attorney is only valid if the principal, the person who's making the power of attorney, has the capacity to revoke it or to create it. Well, that changed in Virginia with the passage of the Uniform Power of Attorney Act. I believe it was in 2010. Now, all powers of attorney by default are durable, which means that they survive a person's incapacity. So the power of attorney is still valid and still effective, even though the principal no longer has the capacity to revoke it. Does that answer your question? I don't know who asked the question.
Fred asked the question.
Fred, is that a sufficient answer for you?
Sort of. What I heard you say is that now all powers of attorney are durable per Virginia statute.
Mm-hmm.
Unless they by their terms say that they are not.
That they're not. Okay, so it'll be specified in there. So for purposes of Virginia, then all POAs are DPOAs.
All POAs that were executed after the passage of the Uniform Power of Attorney Act, which was, I think, in 2010. I don't remember, but whatever that date is, everything that was passed, everything that was executed after that date was automatically durable unless it said otherwise. Before that, it was the opposite. You had to say within the body of the power of attorney that it was durable, otherwise it wasn't.
Okay. So, and for purposes of moving forward, they're all going to be durable by statute. Anything that gets established.
That's correct.
Cool.
That's right.
Okay, thank you.
Unless it states otherwise.
Right, unless internally it says otherwise.
Sorry,
Okay.
we have to add that in. So I think we've kind of covered this slide, but I did want to say, because you mentioned something that I think is important to realize, which is that powers of attorney, durable powers of attorney, can be revoked at any time by the principal. So people worry like, oh, well, I'm going to name this person, but they're a little bit like they could serve now, but they're getting older and I may need to change that out. No problem. You can revoke it at any time. However, you have to have the same capacity to revoke as you had to create. So we have many, many times when people start to lose their capacity, especially when we're dealing with dementia and Alzheimer's patients, they begin to get a little bit suspicious of the people close to them, or they're simply in denial about their condition. And so they might want to revoke a power of attorney that was established back when they did have capacity. And so we're always very careful if someone's coming to us and saying they want to revoke a power of attorney to make sure that they have the capacity to revoke it and to get a little bit more information about what's going on, so that we can make sure that it's not just it's not their disease talking, it's actually them talking, and they really want, it's something that they want. So
this should kind of bring to mind the fact that a power of attorney that you would think would be adequate in most circumstances may turn out not to be adequate because it either doesn't have a successor named or it doesn't have a mechanism for naming a successor without going to court. So
I think we have a slide on that.
Yeah. So
here's a good one.
Go ahead.
Okay. So when you establish your power of attorney, there's a couple of things we're going to say that you practically need to do in order to make it work properly, and this is a big one. You don't necessarily need to give them a copy of it, but you do need to let the person or people know that you're naming, that you've named them. Here's why. So that they can be on sort of lookout for you. We had a situation with a case where there was the oldest son who'd been named as the power of attorney, and he had been helping mom through lots of things. And I'm not sure whether he even had a copy of that original power of attorney or not. I could put his hands on it. But what happened was, as mom started to lose capacity, his sister picked her up one day for lunch and didn't bring her back. So picked her up for lunch, took her to the lawyer to sign a new power of attorney, took her to the bank and opened up new accounts. And the other siblings didn't know anything about it. The son didn't know anything about it. He wasn't sort of on lookout for that kind of thing. So it is important to let the person know that you are naming, that they are named, so that they are aware that if you become incapacitated, they're the person to step up, not someone else who might. You know, people are always, we find, much more interested in stepping up to manage money for their loved ones than they are to manage care. And so it's the money, even if there's not a lot of money, that's where the fights are. So.
Yeah, I guess the other thing I wanted to say about this slide is that it also makes sense to actually have conversations with the person who's going to be your agent about what your preferences are, about how your affairs are managed. You know, it's much easier for the person who's serving as agent to make decisions for you in your interest if they understand the nature of your interest and you know, the specifics of it. So just naming somebody and then never talking about it is not a good solution. And this, of course, goes equally to decisions under a medical directive as well. So,
very important.
You know, people need to understand, people that you appoint in a position to make decisions for you, regardless of the nature of the decision, need to understand what the decisions would be if you were making them yourself. So there needs to be a lot of communication taking place between the principal and the agent in every case. You know, at least that's ideal. We know that these things are difficult to talk about, and you know, not to put too much of a plug in for the firm. I just want to say that we do facilitate these communications as a matter of course during our representation of people in the estate planning process. And if you know of people who need to find somebody who can help them through these decisions, then you know we should be on the list of people that have served as candidates. So here's the problem. You put a power of attorney in place, you name the right person, you have communications with that person about what you want to happen to your stuff in the event that you can't make your own decisions, and yet you trust at that time, without further action or communication, that your bank or your brokerage or some other third party is going to honor the power of attorney that you have created. That's a huge mistake. It's a huge mistake because banks, brokerages, third parties, especially custodians of assets, would typically prefer to keep the status quo. They've organized the assets in a way that makes sense to them and that makes them money. And having interactions with clients that result in funds being withdrawn or transferred out are not the sort of thing that they would really like to do. They only do it if they have to.
Well, and just so that we got Dawn on here, okay? So they're not all evil
Dawn's
banks.
agreeing with me, I think.
Well, it's also that it's liability for them. Okay, when they start allowing someone else to handle your financial assets for you, they have to be absolutely certain that person has the authority to do it, or else they're liable. And so it's not all about, it is about protecting themselves, but it's not just about protecting their control over the assets. It's about protecting themselves from liability.
So tell them how to avoid the problem.
Well, Don has something he wants to say, I think.
Yeah, I just wanted to point out that it's, when an institution has rules like that, and Edward Jones does, it's because we have a duty to protect our clients against fraud and to make certain that everything we do for them is truly in their best interest. So if someone comes into my branch waving a power of attorney at me that I've never heard about from my client, my instinct is to not trust it and think this person's trying to rob my client blind. So definitely communicate. The other part about that is there will be language sometimes that the institution will require the power of attorney to have in it, or certain instructions can't be honored, like you know, whether or not this person is allowed to remove money from the account to pay to themselves.
Right.
That has to be spelled out, or it immediately looks like a fraud red flag and we have to stop it. So communicating that with your financial institution is critical.
This is such a great illustration to have us talking about it from one perspective and having Dawn talk about it from the other perspective, because what it illustrates is that there's a tension between the principal and the custodian over the validity of the agency, which can be resolved ahead of time. And this is what we're trying to say. We're trying to say that communication is the key. And when the principal puts a durable power of attorney in place in favor of an agent, he needs to communicate that to the custodian, so that the custodian can look at the power of attorney and say, yes, we will honor this power of attorney. This power of attorney has all the information that we need in order to empower so-and-so to act on behalf of our client. Or they can say, no, there's a problem with this power of attorney. Our internal regulations and rules prevent us from honoring this power of attorney in this respect, and this is why. And if you've had that communication with the custodian, then you can go back to your lawyer and say, this power of attorney is not going to work. And so there can be a dialogue that takes place so that the power of attorney is modified so that the custodian will actually accept it. Does that make sense?
And I just want y'all to know that, you know, there is the Virginia Power of Attorney Act says that custodians are to honor powers of attorney that are properly executed, you know, and are valid. The practical reality is that that doesn't happen for a variety of different reasons. And when it doesn't happen, while their law says that that there should be a remedy for that, in reality there isn't. We face this with clients who are dying, and we're trying to make sure their power of attorney is on file with the bank or whatever, and the bank is saying they need to come into the branch with their agent and sign the documents, and we're saying they're at UVA hospital and ICU, they aren't going anywhere. And you know, we're not going to be instituting a lawsuit at that point trying to force the bank to comply with Virginia Power of Attorney Act. There's really not anything we can do, very much we can do for our clients at that point. And so we do try and we advise our clients either to do it themselves. In some cases, we're engaged to do it for our clients, and we go through that process. And I'll tell you, for example, we work with clients who have accounts at Navy Federal all the time. I can't tell you how many powers of attorney I've sent to Navy Federal. Just recently, we sent, you know, our powers of attorney have a lot of very similar language in them, and just sent one over to Navy Federal, and Navy Federal came back and said that they weren't going to accept it. Now, I haven't had a chance to follow up and find out why. I'm confident that it's going to get resolved. But just to give you an example, I don't know what it is, but it's not like we're sending really anything different than what we have sent like 10 or 12 or 15 times before. So something is flagged there. We're going to find out what it is and get it resolved. But I'm really glad that we're going to find out about it now while our client still has capacity. If we need to add language or something, maybe their policies have changed. There's also sometimes banks that want you to sign some sort of certification, some sort of notarized document that says that you're certifying your power of attorney. And again, you want to find that out now. You don't want to find it out when the person is already incapacitated and can't sign that form. So sorry to be. I'm
sure you can tell that we're having a great time here, and we're talking faster and faster because we have a lot to say about these issues.
So many things go wrong here.
We got 5 more slides and 10 minutes to do them in, so we're going to just whip right through these. The springing power of attorney is, you know, the traditional kind of power of attorney is one that's the durable power of attorney that says, well, my power of attorney is only going to be effective when I become incapacitated. And there's some provision in it typically to determine incapacity for purposes of the effectiveness of the power of attorney. Well, in Virginia, again, as a result of the Power of Attorney Act, all powers of attorney are standing powers of attorney unless they say otherwise. Now, we highly recommend that if you're appointing somebody who's qualified to be your agent in the first place, that you go ahead and make the power of attorney, allow the power of attorney to be standing rather than insisting that it be springing.
Standing means effective immediately. I'm not sure he said that.
Because, thanks, because, you know, you don't want to be in a situation where you need the agent to act and act quickly, and the custodian has to slow things down in order to be able to be convinced based upon the criteria that are within the power of attorney or based upon statutory criteria that the principal is incapacitated. So, you know, do we need a doctor's note? Do we need 2 doctor's notes? Does the doctor's note need to be a week old? Can it be, you know, can it be a month old? There's all these issues around determining whether the power of attorney is actually effective or not, unless it's built in such a way that it comes into effect at the time that it's executed.
And I want to say this, there are some banks, and I believe UBA Credit Union is one of them, that will not accept a springing power of attorney.
Right.
They just simply don't want to deal with having to figure out what is the trigger that means that you're incapacitated, so they won't accept it.
Well, and like my wife was saying earlier, if the bank has a policy that they're not going to accept it, the client only finds out about it when it's really too late to do anything about it.
But I also want to say that people get concerned. They worry about giving up control. Oh my goodness, I can still manage my affairs. If I sign a standing power of attorney right now that gives my brother, Bob, the authority to do everything for me, you know, how do I know he's not going to go behind my back and start doing things? Well, one, if you're checking your accounts and you are in fact in control of your finances, you'll know if someone's going behind your back and doing things. If they are going behind your back and doing things, that is against the law. That is a violation of even though the power of attorney is standing and gives them authority to act right away, they have a fiduciary duty to act in your interest and not their own. If you have the ability to manage your affairs yourself and they're going behind your back and doing things without your permission, that is not acting in your interest. That is a breach of fiduciary duty, and you can sue them. Now, we as lawyers, believe it or not, do not advocate litigation as a great solution for anything, but it does usually give our clients a little bit more peace of mind to know that they have a remedy if someone does go behind their back.
So let's move along.
And you can revoke it. Okay.
This next one is kind of, we're gonna just try to just barely touch on it because we've only got 7 minutes, but helping a loved one, and here what I mean is, the typical situation is the child, the adult child, starts to realize that mom or dad has a developing issue that is going to result in their needing to have a durable power of attorney. And neither mom nor the child wants to spend the money to go and get it done professionally. So the child goes online and searches around and finds a form, downloads the form and fills out the form for the parent and puts it in front of the parent, and the parent signs it. Well, the case law in Virginia tells us that is actually, believe it or not, that's actually the unauthorized practice of law. Now, whether you accept that as being an appropriate sort of limitation on what a person can do or not do, the result of it legally is that when there's a controversy in court over that power of attorney and its effectiveness, then the court its hands are tied. The court's hands are tied because what's happened is that the power of attorney is the fruit of an illegal act, which means that the courts cannot be called upon to further the effect of that illegal act. In other words, they leave the language in the cases is that the court will leave the parties where it finds them, which means that you don't have any legal recourse. If the power of attorney doesn't work, if somebody does something under the power of attorney that's inappropriate, it basically creates where someone was actually legitimately trying to help. What's actually happening is they're divesting their principle of the effect of that action and actually hurting them. So putting, and I love this argument actually because I wrote a brief on this in one of our cases, and so I really like this argument. But even putting that aside, if you have siblings or other kids, right, and mom or dad is losing capacity, first of all, that's a stressful situation for the family. So even, families that get along great when things are great, throw a health crisis into the mix, and there's likely to be conflict just because we're stressed and we're upset. And so when one sibling takes the parent, this is how it usually plays out, takes the parent, chooses the form, fills it out for them and signs it, it automatically creates suspicion
among the other people who might be interested in trying to help. Taking the parent to a neutral third party who's going to make sure they had the capacity to sign it, who's going to make sure that they're not being unduly influenced, takes that argument away. And the amount of money that it costs to go to a lawyer is way less than the amount of money and heartache that you could go through with having to litigate this, or having to, or finding that it doesn't work at all. So,
so the next argument that we want to make in favor of not going online and doing it yourself is the problem of what happens when you actually need the document. And here, this slide, my wife wrote something different, but I wrote, it's a mistake, or it's a pitfall not to have a warm body with a bar license behind the document that you're trying to use. And I think it probably should be obvious by now that problems do crop up. And if your lawyer is your laptop, then how are you going to get your laptop to pick up the phone and call a custodian and get them to help you, push through power of attorney so that it works? How are you going to get your laptop to go into court and tell the court that, that the power of attorney is effective in order to produce a certain result? How's your laptop going to go talk to the clerk about recording the power of attorney so that a transaction can be recorded in the clerk's records in order for it to be effective? You're not going to be able to do that.
I want to say it a different way, and that is, when these documents, if these documents need to be used, something terrible has happened.
Yep.
Someone is either had an accident, something where they're in a coma, or they're having a serious health crisis, or they're dealing with a serious diagnosis. They're dealing with dementia or Alzheimer's, and they're losing capacity, and that is causing stress for everyone that's close to them. So it's the sort of thing where, to find out that it doesn't work, or doesn't work the way you need it to, only after you need it, it means that you're dealing with a terrible crisis with someone that you love, and you're not able to help them in the way that you need to, and you're distracted by trying to use this power of attorney that isn't working, from actually taking care of them and being with them. So this is one of those things that because it is heartbreaking for us when we meet with people who have a situation where there's really nothing that can be done other than going to court and get a guardianship, and it takes too long, and they're very upset. It's hard for us to deliver that news to people. And that's why we are so adamant and passionate about trying to make sure that people have the information that they need, and that if you have a power of attorney right now that you've done yourself, if you have, please get it on file with all the custodians that your banks, your IRAs, whatever. Make sure that it has the language in there that you need. Make sure that you have named a backup. This is, a couple backups. This happens very often, where you name your spouse and maybe one child. Anytime you're naming a spouse, I would say especially, I think you need 2 backups, because you're with your spouse all the time. And if something happens to you, like a car accident, it's highly likely that your spouse might be in the car with you. And so, and while it's great to have your child as a backup, at least one backup, once something happens to your spouse, then they don't have a backup. So if you have, we're always like, name as many people as you can that makes sense. We don't want you like naming people that you don't know. But if you have 4 kids and you trust all of them, let's name them in order and make sure that there's a backup, for as many backups as we can have. I think we're running out of time.
We're almost out of time. I want you to tell these folks about how, just one example of how a durable power of attorney can be used as a weapon. I think the mom napping example.
Well, I did. Yeah. I mean, so someone's interested in having control over the money and control over the healthcare decisions. And so, this actually happened. Mom was living with another sibling, and the other sister came to pick mom up for lunch, as she often did. She knew mom was losing capacity. She picked her up for lunch and never brought her back. Took her and had her sign new documents, took her to the bank, opened up accounts, changed the beneficiary designations on the account to the daughter that was kidnapping her versus the other kids, changed life insurance beneficiary designations, cashed in life insurance beneficiary. One of the worst things that can happen is that they use it as a way to keep the other siblings from mom. So mom is losing capacity. She's older. They only have a limited amount of time with her. and they're saying, you know, the daughter with the power of attorney is saying, you need to sign things over to me or you're not going to see mom, or just simply not giving them information about mom's, you know, where is mom being cared for? What is her condition? Not allowing visitation. All of this stuff should never happen, and it can be addressed in the courts, but trying to address it in the courts can take months and thousands of dollars.
So we're over our time, and we apologize for that, but we've had fun, and we hope y'all have gotten something out of this. Anyway, this is our contact information in case you need it.
And we're happy to answer any questions if you have any questions. And we thank you.
Thank you.
And Angie's internet went out.
We lost Angie.
Yeah, Angie's internet went out, and so she's not here at any rate.
Do we have any questions? Any questions, anyone?
So we've got some chats. Let's see what the chat says. Tulia didn't see the slides. I'm sorry about that. We didn't see this until just now.
I think
I've turned the slides off. 5 wishes.
Yes, that document is a great document. It's not going to take the place of a durable power of attorney, but it's a wonderful way to think through what your wishes are and to communicate your wishes. I think it's a beautiful document. Sometimes we've incorporated that into our plan for clients who have it, or they do it in addition to that. Yes.
So
take the POA to the bank before it's signed.
Yeah.
No, I wouldn't say that.
Oh, before it's signed.
I think that's what it said.
Before
before the custodian needs to act. Yes,
Right.
Definitely take the POA to the bank before the custodian needs to act, and tell them that you want to put it on file. Now, I know there's at least one bank that says they will not put it on file until it's actually needed. I don't understand that. But
Julia wants to know how much the drafting costs.
we'd rather have that discussion, Tulia, and a separate discussion, because we don't usually do these documents piecemeal. We do them as part of a plan because it's the responsible thing to do. There have been occasions where we've done them piecemeal, but it's a very specific occasion. But we don't charge for initial consultations or phone chats, so we'd be happy to talk to you about that.
Thank you.
Any other questions?
Thank you for letting us take your time.
This is Fred, as long as you're taking questions. Sometimes people will try to figure out what's the threshold for needing an attorney because of the expense, okay?
Mm-hmm.
And so what I'm hearing is the threshold is if there's any realistic possibility of concern within a family in particular, that folks may not all be on the same page, trust issues, you've identified the DPOA, and the backups should be trusted individuals. If there's any questions whatsoever within a family that this could possibly be contested, that's kind of an automatic need for an attorney, because you need to make sure that this is done more carefully. But I don't want to say that you should automatically get that doing a DPOA requires an attorney, or are you basically advising you should always have an attorney?
So that would be my advice. I'm not sure what Michael's about to say. That would be my advice. And here's what I would say. If you cannot afford these documents.
I'm sorry, what you're saying is you always need an attorney to do
I would
a DPOA.
say yes.
That's your advice?
Yes, because, and even if you don't have very much money, if you become incapacitated and someone needs to do anything for you, like pay your mortgage or, you know, pay a caregiver, and they don't have the authority to act, they need a power of attorney. That's my opinion. But I want to say this, if you have people who can't afford documents, JABA has an excellent program called Wills for Seniors. We participate in it, and they vet people. They have the program a couple times a year, and you get a free estate plan. If you can show that you have, you know, that you aren't able to pay for it, they have lawyers come in from Charlottesville, and we are lawyers that participate in that plan, and you can get a free estate plan with a lawyer. Okay, that's one thing.
That includes the will, it includes the DPOA, it includes the medical directive. So
that's a way better solution than LegalZoom, which is not free.
Mm-hmm.
Now, having this first of all, the consultation with the lawyer is free with us, and
with most lawyers.
And getting it done is just we're talking hundreds of dollars. We're not talking thousands of dollars for something very simple. All right. So it's my opinion that yes, for a durable power of attorney, you should consult a lawyer because it's a very powerful document. A lot of things can go wrong. And if it doesn't work for you in whatever context, first of all, your loved ones could find themselves in a very difficult position of trying to help you, but they also may find themselves having to go to court, even if there's no argument, because the power of attorney doesn't work, they have to go to court for a guardianship anyway, and they find that out later. So if your clients want to do it themselves, and a lot of people do, just make sure that they take the document and take it to all the banks and get it on file and find out if there are any issues now. But I still, because it's such a critical document, so many things can go wrong, and when they go wrong, it's because they're going wrong in the context of a crisis, of a health crisis for someone that they love. That I would suggest that spending the amount of money that you spend on a lawyer, even just to consult with a lawyer, which again, the consultation is free, is well worth it. But you know, we're coming at this, I always tell people, we see the worst cases, right? We see the cases when things don't work out, when people are fighting, when somebody did something simple that they thought was the right thing, and it turns into this terrible situation at the worst possible time. That's what we see in our office, and we see it more than any other problem that we deal with, which is why we chose this topic to talk about today. But Michael has something you want to say, honey? I'm sorry.
No, I just basically want to say if you're doing a balancing and the cost is zero, right, which is what the consultation is, zero, you have the consultation, get the information, and then you can do your balancing act, determine whether it's worth it to spend the money, which now you know exactly how much it'll cost. You know, lawyers giving you information about where it could go wrong. Then you can take the risk at that point. It doesn't make sense to just have an arbitrary sort of threshold, which is, oh, do I imagine that something might go wrong? Nobody imagines that something's going to go wrong when it goes wrong. Nobody's imagined it. It just spontaneously erupts.
The reason why we don't quote fees also is because sometimes people come into our office and they say everything is simple, and it is. Many times people come into our office and say everything is simple, and when we sit down and talk with them and have a little bit more of a conversation, we find out that it's not. And so I will tell you, that's why we don't quote fees, because I don't want to say, oh, it'll be X number of dollars, and you send the person in and I find out that there's way more going on. We've had the opposite conversation. And, we want you to know this, that we've had clients come in who've been to a seminar somewhere and they're absolutely determined that they need a trust. And they come in and sit down with us and we say, you don't need a trust. We can do what you need to do with a will. If you want us to charge you for a trust, we'll do it, but we can do this for a lot less money. And I know it's hard I'm a lawyer saying trust a lawyer, which sounds crazy.
Insane.
It sounds insane, but I'm just saying that we do really, we work in a small community, and I grew up in a very, very rural community. And, we want people to know that if they come to us, that they can trust us to tell them, that how much it's going to cost and if what they need and what they don't need. And that's why we really want to have a conversation rather than just sort of arbitrarily quote numbers or say things like that without all the information. Does that make sense?
It does.
And Fred, I want
That's
to
very helpful. Thank you.
I want to back these guys up. I have encountered situations where, I'm dealing with savers that have, worked their whole lives spending as little money as they can, and that's why they feel they're doing well in retirement. And so when I tell them get a lawyer, they resist and say, I can read about it, I can write it myself. And I always cringe at that because I just know if anything about this is ever challenged, you are going to be in such a problem that it's unfathomable. And if that's happening after you've lost the capacity to care for yourself, then your assets are going to be useless to your entire family between that day and the day you die. And what sort of trouble is that going to cause? So there are lots of lawyers, lots of different fee levels. Find the one that's right for you and pony up the cash.
There are a lot of great lawyers in this area, lots of them.
I wanted to
Yes, Regina?
I wanted to say a couple things and then ask a question, but I know JABA does the wills for seniors, but it's really just for seniors, but everybody needs a POA. anybody at any age of majority, if you're not married, you need a POA, because at any time something could happen that would incapacitate you. And that came to light for me when I moved to Virginia from Indiana and was involved in a car accident on the way. And I wasn't hurt, and that was great. But what I realized that nobody could have stepped in to do anything for me because I hadn't done that. If I had been incapacitated, no one could have taken care of the rent in the apartment I just came to. Nobody could have taken care of my car payment. Nobody could have accessed my bank accounts. Like, nobody could have taken care of anything on my behalf to keep my financial stability because I was in the middle of this move. So everybody needs one. Everybody needs to set a beneficiary, a death beneficiary on any account they have. So at the moment, if you are, if you do pass away, that somebody can access those funds immediately without having to do anything. So a death beneficiary in any account you have, a POA for anybody that's single, even if you're 18, like, it's time. Because nobody could step in and take care of your affairs. And the question that I had is, what happens if you move a durable power attorney from one state to another? Does that make a difference?
So it is a great question. I'm going to let Michael answer your question. I just want to say thank you for your comment. I used to joke that when my kids turned 18, I was going to have a notary at the house at 12:01 a.m. on their birthdays to sign documents. And actually, they both are now over 18, and their documents, actually, Dawn has seen some of their documents. They are like the day after their birthday. I totally agree. Michael and I had talked about right before this COVID-19 thing happened, because the Wills for Seniors is in Charlottesville, about trying to do one out here in the Louisa, Fluvanna area, because we don't have that same resource here. And a lot of folks come to Charlottesville for that. But one just for low-income folks, not just for seniors, but for anyone who cannot otherwise get access to these documents. We're very interested in doing something like that. We've also talked about, during this particular situation where people are really thinking about being incapacitated, so on a ventilator and hopefully recovering, hopefully not dying, some sort of just power of attorney package for right now. I don't like to do it that way, because really, if you're thinking about these issues, you should go ahead and do a will as well. But because we can sign those documents, Angie has an electronic notary, and we can consult, draft, and sign the documents completely virtually right now, doing something like that to make those documents extra accessible during this time. So that is something we're thinking about. And Regina, thank you for raising those issues.
So the answer to your question, I can give you the answer to your question from a Virginia perspective, really. And that is that in Virginia, your durable power of attorney is effective if it was executed correctly in Virginia, or if it was executed in another jurisdiction correctly according to their rules. So if you have a Texas power of attorney that was effective in Texas because it was executed under the Texas provisions of their power of attorney law, then it's effective in Virginia. Or if it was executed in Texas and it would meet the formal requirements for execution in Virginia, in other words, the signature is notarized is the only requirement in Virginia, then it's effective in Virginia. Now, I can tell you, generally speaking, that a lot of states, and maybe all states, have similar provisions about making foreign powers of attorney effective in their states. But I can't definitively tell you with respect to any particular state whether that state has those provisions. Does that make sense? So we're way over time.
One thing to make sure that the group knows, especially since we all care for seniors, retirement accounts, that I in front of IRA means individual. Your spouse does not have any access to that thing. So if you're taking withdrawals out of that to meet the family's needs and you lose capacity, your spouse can't go to the bank or to Edward Jones or anyplace else and say, give me money from his or her IRA. That's also where power of attorney becomes effective.
Right.
Okay, so,
and there's at least one other lawyer in this group who's not here this morning, Doris Geldman. She does this work as well. She's outstanding. So, and there's lots of lawyers in Charlottesville as well that do this work. So y'all have lots of choices if you decide to talk to somebody about it.
Well, thank you.
All right. Thank you.
You're welcome.
Y'all have a great weekend. Thank
You
you so much
too.
for letting us speak
You too.
this morning.
Oh, you're welcome. Thanks for joining, everyone.
I
All
miss
right.
all you guys. We'll
Bye.
see you again soon.
Bye.
Informative meeting. Thank you so much.
Thanks for
Thank
joining
you.
us.